Hey, folks, thank you once again for joining us this evening for the Nassau-Suffolk School Board Association's annual webinar for a legal update. And we are pleased that so many of you have signed up. We had over 115 people register. A lot of you are joining us live. Many will be seeing it on demand afterwards. And we thank you for your support and participation. We also want to thank our sponsor for tonight's webinar, Land Rover. Visit them at landrover.net. Great technology company right here on Long Island and a big supporter of the work that we do here at Nassau-Suffolk School Board Association to bring you some events and content that is relevant to helping you and your governance teams be the best that you could be. And before we get started and introduce our attorneys who have graciously put this presentation together for us tonight, on behalf of the team, the board of directors, the officers, and myself and Lorraine Mentz here at Nassau-Suffolk School Board Association, we want to wish you and your families a very happy, healthy holiday season and a happy, joyous new year as well. We've got a lot of work to do in the coming year, and we're proud to work alongside of you. Like I said, this is now, I believe, our third annual legal webinar, and our team tonight, Mr. Howard Miller from Bond Schoeneck King. I believe you're 3 for 3 there, Howard, with being one of our presenters, and you brought in one of your heavy hitters this year, Candace Gomez. They are part of BS&K and part of the education law practice, and they represent a lot of the school districts here on Long Island, and the firm represents a lot of school districts among other entities across New York State. They are a good friend. They are always willing. Anytime I pick up the phone and call Howard, he hasn't said no yet. So that's a good sign. So let me introduce Howard Miller and Candace Gomez, and I'll turn it over to you guys to get us started. And thank you for putting this together for us. You know, not that there's too much legally going on out there in the education space.
No, not at all. First, a little disclaimer. One, as I'm speaking to you, I just got an emergency call from a school board in session. I'm going to jump off for 1 second. I apologize for that, and I will be right back. Bob, is that okay for like 2 seconds?
Listen, clients come first, and listen, school board service always comes first. And that also gives me an opportunity to remind folks during the presentation, if you have questions or comments, post them in the Q&A. I'll be monitoring the Q&A, and we'll be sharing that with Candace and Howard. And now we know why he brought in Candace, because Howard is a busy guy, but Candace has been in this business a long time and very, very talented attorney herself. Candace, welcome to our webinar, and thank you for putting this together and taking some time out of your busy evening to share some of your wisdom with us. So go ahead. Just have to unmute.
That would be a good first step, right? Thank you so much, Bob. Always a pleasure to be invited to this wonderful program, and thank you for having us. Howard was actually going to tackle the first few slides, but maybe what I can do is go through slide 8, which is where I was going to pick up, because it does deal with transgender students, which is the topic that Howard will be covering in the beginning. And we'll kind of do it a little bit out of order, but we'll get all of the same information presented to you at this time. So if we could go, I think, let's go one more, Bob. We're looking for the slide that says transgender students' bathrooms and locker rooms. There we go, right there. Perfect.
Hi. So sorry about that. So sorry about that.
No worries, Howard. We were ready to pivot, but we could pivot right back. So
yeah. So if we could go back to the beginning. So I really apologize, but sometimes boards have an emergency right then in real time, and we got to do what we got to do. But
that's a good way to market your excellent customer service skills, Howard. Well done.
I don't know about that. Bad way to market my speaking engagements, but a good way to market the other. So one disclaimer before we start. Ordinarily, I'd be doing this from my desk at work, but for various reasons, I had to do this at home. I've tried to pick the most isolated part of our basement, but there is a chance that either my dog Katie or my cat Oliver will crash this party and want to chime into the discussion. So I just want to let everyone know, to the extent that you hear them, they are expressing their own personal views and not the legal advice of Bond Schoeneck King. So with that, if we could get to the first slide. So I think to a certain extent, this slide somewhat sums up where we are, that we get sued for everything these days. If we could just go back to that. If we really wanted, though, to complete the picture of what school boards are facing these days, also standing in front of that teacher would be Lucy with her attorney Woodstock saying, if you do not give us homework over the holiday weekend, we will sue you. Peppermint Patty then would take out a copy of an executive order signed by the president saying it is unlawful to give homework over the holiday vacation, to which Lucy would respond with a copy of guidance from the New York State Education Department saying you must give homework over the holiday weekend. So what are we to do with these conflicting advice other than drinking heavily? And I think what we're going to try to do here is to take you through how we navigate where we get conflicting rules from the federal and state governments, and we can be sued no matter what we do, and what's the best way to go through that. So as we go forward, we're going to be talking about transgender athletes. We're going to be talking about the rights of transgender students to use bathrooms of the gender with which they identify. We're going to be talking about some First Amendment and religious speech in the context of the use of pronouns, also advising parents when their child is transitioning. And then we're going to talk about school districts trying to navigate things like pride flags, crosses on the walls, and staff political speech or religious speech that could create a very controversial environment for everyone. So I'm going to start with two cases that are going to be heard by the Supreme Court this term. Actually, I believe oral argument is next week. And for those of you who are interested, you can go on the Supreme Court's website and listen to the live oral argument. And I think these cases are going to be very interesting. And I did speak about these two cases at the NYSBA pre-law conference. So for those of you who are hearing me do this again, I apologize for the repeat. And for those who are hearing it for the first time, I apologize for even going through this case in the first sense. They are very complicated.
And so, Howard, if they're hearing oral arguments this week, let's say, when do you think decisions typically will come out?
They still wait until until June, typically. Not all the time, but it could be that long. And we certainly would love answers before certainly the spring sports season, because a lot of these cases come up in the context of track and field.
But from the context of a board member, any changes from legal statute will probably impact us the school year coming up 26, 27. Correct. So it's good to have that background, and it's good to pay attention to the news to see what may pivot or adjust. Thank you.
And we may be able to read some of the tea leaves from the oral argument, but that doesn't necessarily mean for certain it's going to go a certain way. So the two cases, one involved a transgender athlete at the college level and one at the high school level. So in both of these cases, they ruled in favor of the student, but they ruled in favor of the student on very, very narrow ground. And what they did was both cases took a deep dive on the science that was at issue in this. So the first case, you had a female, a transgender female, who had tried out for the track team at Boise State and didn't make the track team. And then she decided she wanted to try out again the following season. But in the interim, Idaho passed a law making it unlawful for biological males to compete on women's track teams. And so she filed a lawsuit challenging that ban. And the case went to the Ninth Circuit, which sits in California. It's a federal appeals court in California. They ruled in her favor. So Bob, you can go to the next slide. And what they looked at is, again, based on the science, what makes a male, what gives them a competitive advantage in sports in terms of muscle mass and the like, is circulating testosterone. And for this particular athlete, she had taken puberty blockers for quite some time. She did not have a biological male's levels of circulating testosterone. So she could not have a competitive advantage versus a biological female. And the proof in that is that the first time she even tried out for the team, she didn't even make the team. So this was not one of those situations where you had a biological male, if they were allowed to compete, for sure they're going to win, a Division I title. It wasn't like that. So the court, on very, very narrow grounds, said under these particular circumstances, it would violate the Title IX rights of this athlete not to let her compete. So if you can go to the next slide. So the next case, we have a 13-year-old middle school student who wanted to be on the cross-country team. She had started to transition when she was in 3rd grade. Her parents even changed her birth certificate. She had been considered a girl in the eyes of the school district since 3rd grade. She had also taken puberty blockers for quite some time. West Virginia had a law like Idaho's that said can't have a biological boy competing on a girls' team. She sues the state, and she also sues the school district. And the school district understandably says, well, wait a minute, why are you suing us? We're just following state law. And the Fourth Circuit, which is a federal appeals court that sits in Virginia, makes this statement, and I think it's important for everything that's going to lay in front of us. Federal law trumps state law, not vice versa. And those who violate federal law cannot defend on the ground that they were simply following state law. And that becomes an important concept. So federal law creates the floor, the minimum standard for people's rights. State law can grant more rights than federal law, but they can't take them away. So in this case, the court found that this student was basically biologically a female as a result of the puberty blockers, that she had no competitive advantage. Not only that, there was unrefuted testimony in the record that she would be at a competitive disadvantage if she was forced to compete against the boys. So on very narrow grounds, the court finds that as to this particular student, it would violate her rights under Title IX and under the Equal Protection Clause to the Constitution to deny her that right. But the court said something very significant in the end of it. They said, we do not hold that government officials are forbidden from creating separate sports teams for boys and girls, or that they lack the power to police the line between those teams. We also do not hold that Title IX requires school to allow every transgender girl to play on girls' teams, regardless of whether they have gone through puberty and experienced elevated levels of circulating testosterone. So they're walking a very fine line. So what are the possible outcomes here? The Supreme Court could say, well, we're gonna uphold the 2 decisions from the federal appeals courts on precisely those grounds. We're not holding there can never be a ban, or we're just holding on these particular facts where there's been puberty blockers that it would violate Title IX and or the Equal Protection Clause to deny them access to that team. Or the Supreme Court could say, you know what, we're going to take this opportunity to say categorical bans are in fact lawful. Now let's say the Supreme Court does that, but they stop there. What does that mean for us in New York? Well, in New York, we still would have state law, which would allow them to compete on girls' sports teams. But what if the Supreme Court went one step further than that? If they were to say, not only do they not have the right to compete on girls' teams, it would actually violate the Title IX rights of female students who are on those teams. If they went that far, then that would trump state law, and that would be the law. So we're all waiting on that to see how far they go. And with that, I'm going to give the baton over to Candace to talk about the bathroom issues.
Thank you so much, Howard. So yes, let's talk about the bathroom issues because of course this is always a hot topic in terms of school boards trying to figure out what to do, rightfully so because the ground is constantly shifting underneath us in terms of which way to go. You'll see that as I give a brief description of each one of these cases, the circuits, meaning the courts in the different jurisdictions throughout the United States have decided very differently concerning these cases. So we will need some type of guidance from the U.S. Supreme Court, I suspect, at some point in order to really know for sure what the law is in a situation. As of right now, we are following the law set forth in the state of New York, which requires that schools recognize the rights of transgender students. Of course, there have been various guidance documents put forth by SED stating that a school should allow a child to use the bathroom that conforms with their gender identity as opposed to their biological sex. Or in the alternative, if the student would like to use a gender neutral bathroom, that also needs to be offered as an option. But we see that in many of these cases, the gender neutral bathroom was offered and the student did not want to exercise that option. So let's talk about what happens in those situations. The first one is the Whitaker case. This is a Seventh Circuit case that came from an appeal in the state of Wisconsin. And in that case, we have a 17-year-old student named Ash Whitaker, trans boy. So this is a student who was born biologically female and identified as a male, wanted to use the boys' restroom. The school said no, it invades the privacy rights of the biological boys that are using that restroom. And part of what I believe helped him to win this case is that although the school told him, no, you can't use the boys' restroom in his sophomore year, and he complied with that, by his junior year, I guess he decided he was going to kind of go off on his own and do what he thought was right, began using the boys' restroom unbeknownst to the school, and used that restroom for a period of 6 months before anyone noticed it or took issue with it. At some point, a teacher noticed him in there washing his hands, reported it to administration, and told him that he needed to stop. And that is the impetus for this case, because at that point, he sought an injunction that would prevent the school from enforcing their policy of making restroom use based on gender, biological gender, as opposed to gender identity. And part of what I believe helped him win this case is that he was using the boys' restroom for 6 months and it was never an issue, never a privacy problem with the other boys in the school. And the court found that there really wasn't a basis for the school's fear that this would cause some type of real disruption or privacy issue with the boys in that situation. So that's one case. We have the Grimm case, which received a lot of media attention over several years, so I won't spend too much time on this case. This is a case out of Virginia. This was also a win for the transgender community in the sense that the court ultimately found that the board could not exclude Gavin Grimm from using the boys' bathroom and that it would cause harm to him if he was forced to use a bathroom that did not comply with his gender identity. We have a contradiction when we get to the Adams case. This is a case out of the 11th Circuit, and this was actually from Florida. So I think we could all predict that a case out of Florida probably wasn't going to be a win for the transgender community, just given the political landscape that we're in right now. And in that case, the court rejected the argument that causing or requiring students to use separate bathrooms would be a violative of their rights. In that Adams case, we had a student who was born biological female, identified as a male, was in the ninth grade, similar to the case that I talked to you about at with the Whitaker case, began using the bathroom of the boys' bathroom in violation of the school's policy. And it was a period of a few weeks, not as long as the Whitaker case, that he was allowed to use it and no one took issue with it. But once the school realized it, they told him to stop. He brought a petition to the court, and the court ultimately did find that the school's bathroom policy did not violate the student's equal protection clause or Title IX that the student had the right to use a gender-neutral bathroom or a bathroom that conforms with their biological sex, and they did not find in favor of the transgender student in that case. We had the AC Metro case out of the Seventh Circuit. So that was an appeal from a court in Indiana. It had facts similar to Whitaker, and that also was what we would consider a win for the transgender student. And finally, we have the Terrell case, which is out of New Hampshire. We don't have a final decision yet in that case, but in this case, we actually have two transgender girls, so students who were born biological males, identified as female. They wanted to use the women's bathroom and also participate in women's sports. And in this situation, the court needed to decide whether or not a certain group, this was a group intending to protect the rights of female athletes, wanted to intervene in the case and be a party to the case. And it needed to be decided as to whether or not they would be allowed into the case to help defend. While this was going on, because the case was filed in 2024, of course, we had a change in administration. In February of 2025, President Trump comes along and he issues an executive order titled Keeping Men Out of Women's Sports. And in that order, he asserted that it's demeaning, unfair, and dangerous to women and girls, as well as violative of Title IX to allow transgender girls or women to play women's sports. So, of course, as a result of that order, a lot has shifted in terms of the way the courts may look at this. And at this point, we're waiting for a final decision to see what will happen in that Terrell case. And as I close out, we know that there was a very recent commissioner's decision regarding a Long Island school district. In this school district, they passed a resolution to prohibit transgender students from using bathrooms and locker rooms that do not align with their biological sex. And the Commissioner of Education, Dr. Betty Rosa, weighed in on this on November 18th, and she issued an order stating that the school district needed to go ahead and allow students to use a bathroom or locker room that is consistent with their gender identity. So
So
that gives us
probably a future case. We had a question in the chat, Candace and Howard. What impact will Article 6 and the 10th Amendment to the Constitution have on the decision that it is about to be rendered by the U.S. Supreme Court? If the Supreme Court can actually void state law, can we still be considered a federal republic? Or are we now living under a monolithic government with only minor powers, the ability to sweep streets and regulate utilities being reserved to the states? That's kind of a big, heavy question there on
It's a
a
big
nice,
question.
nice, warm
Yeah.
Wednesday night here.
So, the Supremacy Clause allows the federal government to operate in this field and take precedence over a state law. So Title IX would, assuming the Supreme Court were to say it violates Title IX to allow a transgender student to use, let's say a transgender female to use the girls' bathroom because they are biological male. That would be it for us. And unless, now again, a new administration comes in, a new Congress comes in, and they amend Title IX. So through the representatives of the states, we would be able to, well, not we, they would be able to amend the law. And just touching upon that, there were a couple other cases in this field where you had another federal appeals court weigh in the Ninth Circuit, and they sided with the 11th Circuit. Then the Fourth Circuit yet again said, well, we understand what the 11th and the Ninth Circuit are saying, but we're still sticking to our guns. And that was in a case involving a South Carolina law. The state of South Carolina then asked the Supreme Court to jump in right then. And the Supreme Court said, no, we're not going to jump in now. But that doesn't mean anything about how we think about the merits of the case. And there were actually Justice Thomas and Alito said, no, we would issue a stay right now. So we know two justices of the Supreme Court, how they feel. The other thing is there is a school district on Long Island that filed a federal complaint seeking a declaratory ruling saying we are caught in the middle between state and federal law, with each one having the ability to withhold funds from us depending upon what we do. You tell us what the law is. Here's what we think it is, but you tell us what the law is. We'll have to wait and see, and what the Supreme Court does with all of this. So to answer your question, the Supreme Court will state what the law is, and the federal law will supersede state law.
Thank you, Howard. All right. So we'll advance to the next slide.
Okay, so this is again a similar line of inquiry, but so we have our state guidance and we have our DASA law, and in New York, students could be accused of bullying if they do not use the proper pronouns for a transgender student. This is a case out in Ohio where a school district had a policy that said just that was harassment, not to use proper pronouns. And a group of parents challenged that, and they said, well, we, as a matter of our strong religious beliefs, don't recognize more than two genders. We just don't. And we don't want our children to use pronouns that would be different than another student's biology. So they went into court. The lower court ruled in favor of the school district. And then the way federal appeals courts work is that initially there is a 3-judge panel of an appeals court. Same in New York. And I have to say, having argued many times before that 3-judge panel, 3 judges are more than enough. But there are times when an issue is so controversial that the entire group of judges that make up that circuit will hear it. So you could find yourself, it's what we call an en banc review of a decision. It could be 11 judges deciding on this. So the 6th Circuit decides to take this en banc. And even with that, there becomes split. But the majority rules in favor of the parents. And they find that when you're directing a child to use a certain pronoun, that is what we call compelled speech. And they're saying that that would violate the free exercise rights for religious purposes. Now, there was a dissent, and the dissent said, well, wait a minute, the policy doesn't require any student to call any other student by a preferred pronoun. It just says if you don't have to use pronouns, you can call the person by their first or last name. You are not required to use pronouns. The policy says only when you are purposefully calling someone by the wrong pronoun, that is harassment. So majority, what you're saying is just not factually true. But what the majority responds is, well, it's too easy in conversation to even stop yourself if you're used to using certain pronouns. And we think that that policy is just too broad and we're striking it down. So again, that's the 6th Circuit, and they're ruling it on religious grounds. Now, what would our federal appeals court in New York do with this? Well, we don't know, but there was an oral argument last week in another case. And if we can move on to that next case, where, so Bobby would be, yeah, there we go. So this case gets argued, I'll talk about it in a second, but during the oral argument, the 3 judges of the 2nd Circuit hearing this case raised that exact hypothetical. And what the court seemed to suggest, at least their view would be, no, a school district could absolutely have a policy that makes it so you can't purposely use the wrong pronoun. What the Supreme Court will do with this, if they take it, we don't know. Again, the Supreme Court is extremely protective of religious speech. And going to that, what is kind of out there in both of these cases is the recent case that the Supreme Court upheld a parent's right to religious opt-out of certain books about transgendered students. And the Supreme Court, again, made very clear that they will back religious rights of parents. So this case, it comes out of Skinny Atlas. My colleagues in our Syracuse office handled this case. So here you have a school district that followed state guidance and honored the wishes of a student not to inform their parent, at least not initially, that a child was transitioning and wanted to be called by different pronouns. They eventually did notify the parent about 5 weeks later. Parent brings a lawsuit, again, saying this violates our constitutional rights to the free exercise of our religion and also violates our right in terms of how we are going to bring up our child. The district court in the Northern District of New York, a federal court, ruled in favor of the district and says, no, the free exercise clause doesn't come into play here because it doesn't mandate that a school notify you of anything. We're not barring you from practicing your religion or telling you what your child ought to believe. We're just saying there's no free exercise right to the notification of the parent. Oral argument was last week. It was about 2.5 hours long. The judges were struggling with it, but the judges appeared to side with the school district here and with the state's guidance. And what they seem to be saying is that, yes, parents have a right to freely exercise that religion, but that right, when it comes to a child being in a public school, doesn't mean that that schools have to notify parents of everything that is going on in the public school. So with these decisions, let's say the Second Circuit continues to rule in favor of the school district. Does that mean that school districts are safe to continue to follow the state guidance of not notifying parents? In my opinion, and I think Candace shares this as well, we talked about this, it's very dangerous for a school district to follow that guidance. So first of all, we think the Supreme Court would take a very different view of that. And again, because they are very protective of religious rights, would say a school district should notify the parents of this. And again, we go back to the Supreme Court case, the Mahmoud versus Taylor, of the notification of a right to opt out. The other thing that concerns us is putting aside federal law and whether it's a free exercise violation. There could be common law liability for failure to notify a parent. And you know, Candace and I have talked about this, and one of our former colleagues who retired many years ago told me this story about how when he was a young attorney representing a school district. This was before the Supreme Court had entertained the issue of abortion rights. And a school district called him, a superintendent, and said, a student has come in, notified us that she is pregnant and that she plans to get an abortion. And she says, do not inform her parents. They will, you know, be angry with her, they'll kill her, whatever, you know, that kind of language. And the school didn't know what to do. What do we do here? And there was a lot of back and forth about what to do there. Eventually, they decided they needed to tell the parents because the child's health was at stake. And the parents were like, thank God you told us, because there's a history in our family that we never told our child about of extremely horrible allergic reactions to certain anesthetics that could actually be fatal. And we needed, without you telling us that, she could have gone and had this procedure without notifying, you know, without knowing, and something awful could have happened. So extrapolating that, a lot of times children who are going through this are going through emotional turmoil and may need some outside assistance. And to me, at least in my opinion, and schools should have checked with their own counsel about this. It's dangerous to withhold that information from a parent. on the assumption that the parent won't be supportive of their child. It seems to me that a parent ought to be in a position to get their child assistance if they need it. And again, let's look at the worst case scenario of a child harming themselves as they're going through this. And it's because they're struggling with this. And a parent were to come to the school and say, you mean you knew about this and you didn't tell me so I could get help for my child? And I just wouldn't want to be in that position, notwithstanding what the state guidance says. So again, that's something you want to check with your own counsel about, but you know, we've taken that position.
Yeah, and that kind of dovetails into another question and conversation going on in the chat here, is that you know, board members take an oath, right? And you're taking an oath to both constitutions, and the question is, if you don't follow the state law, you know, what exposure does board members have, right? And we know there's there's threats of removal from office, which is the power of the commissioner. Of course, you're going to be named in the suit, but you know, as long as you have done your job as a board member, you should be okay personally, correct?
Yes.
So get into that a little bit, because I think that could be a concern for some.
So let's break that down a little bit. So and that's the reason why the declaratory judgment motion, a complaint was filed. We have competing edicts, and what are we to do with that? So you are entitled, at least in federal litigation, to something called qualified immunity. And first of all, you're indemnified by your insurance carrier and by the education law for good faith decisions that you make. Qualified immunity means you can't be liable unless you violated clearly established law, which you wouldn't be, because as we've discussed, there could be nothing less clearly established right now than what the law is on this. So the other thing is, when we talk about once we get a ruling from the Supreme Court, then that will be it. And again, assuming the Supreme Court were to say, no, it violates the rights of female students in the bathroom case or the athlete case, then state law really doesn't exist anymore on that topic. It's been superseded. As a matter of constitutional law, it's been superseded. But again, now let's go back to the Supreme Court doesn't go that far. All it says is there's no right under Title IX for these things. Then you would be bound by state law. There would be no superseding federal law. So I hope that I explained that. If I didn't, I can try again.
Well, if not, what I was going to say, if you're in the middle of this controversy, I hope you're having a lot of conversations with your board counsel, because don't wing it by any stretch of the imagination. And here's another interesting question that came up too: are biological male, female legal terms, or is it just rhetoric? So from the phrase biological male, biological female, is that a defined legal term that is, you know, there's precedent behind the term itself?
Yeah. So in these in SED guidance, they have a definition of terms: cisgender. There's a whole panoply of new words, at least new for me, that they were about what these words were. So they are defined. What becomes more problematic, and this is where the courts are struggling with, well, what does Title IX mean? If you are discriminating on the basis of sex, definitionally, somebody's transgender identity is their sex. So at least some say. Now, again, the 11th Circuit and the 9th Circuit say, no, that's not true. But the 4th Circuit and the 7th Circuit disagree with that. And hence why we need the Supreme Court to give us an answer either way.
So,
and if I could just...
That legal term, then, I'm sorry, Candace, that legal term is, I guess, still out there in flux a little bit.
I would say so. And just to chime into your last question, Bob, about people having ongoing conversations with their attorneys. To the extent that some board members may or may not agree with transgender students being on certain sports teams or bathrooms, they have the right to their own personal opinion, of course. But even beyond the Title IX issue, they should keep in mind that to the extent they want to engage in public debates about that, and perhaps during a board meeting, have a conversation with other board members about whether or not they believe a transgender student should use a certain bathroom, let's say, or whether the pride flag should be hung up in the classroom. Even beyond Title IX, there may be a transgender student who says, as a board member, you're sitting on the dais supposedly speaking on behalf of the district, and you're saying things that are offensive to me. Maybe now I think that I have a DASA claim against you in the district.
Yeah.
Or maybe I am a transgender employee working for the district, and I'm hearing this public debate in board meetings where you're saying there's only two genders, and I don't believe that we should be allowing this in our school district. As a transgender employee, maybe now I'm saying I feel that I'm working in a hostile work environment because it's clear that those who are leading the school district are not in favor of my lifestyle and the way that I identify myself. So if those things come along, we should be cognizant of the fact that we're not only worried about Title IX, we're also thinking about all of the other legal claims that could be brought as a result of people's opinions.
So,
And
to that,
there's a brand new legal case literally just
yes,
hitting the wires that is
yeah,
going to test that versus the First Amendment right of a
yes.
board member. And
So
literally that is fresh off the press.
yeah, I read the complaint yesterday. It's very interesting. So the state issued guidance in joint guidance from Commissioner Rosa and Letitia James. So in making that precise point that Candace just made, and saying that that is a matter of policy of the state. And so that just a few days ago, a lawsuit was filed in federal court in Albany, alleging that that violates the free speech rights of board members and community members, because the guidance also says you should shut down community comment too. And Candace and I, so just to give you a behind the scenes thing, we were talking about this, and we were talking about, well, what does this mean? Does the First Amendment give you that right, or when you're in a public, when you're sitting up at the dais, is that right limited? And we were getting a little bit dizzy from talking about all the implications, because could you make then, if you have a First Amendment right to say, well, no, only two genders? Could you say, I think homosexuality is an abomination, or I think there's only one true religion, or something like that? And now certainly in your own private time you could say those things. That's
but when you're in your capacity,
yeah, that's the beauty
as a
of our
school
First
official,
Amendment. Yeah, could you? But when you're sitting up there as a board member, could you do it? And let's say, again, if we take transgender out of it, but if we look at any other protected characteristic, race, religion, whatever it may be, disability, could we allow a community member to just go off in public without shutting them down? I think you'd have to shut them down. But again, this is what the courts are for, to tell us what the rule is going to be on this. And
it's going to be interesting to see how it plays out.
It is going to be interesting. In the meantime, it is rather agita-inducing to see all of these things that we don't have clear guidance on. But in the meantime, I would, talk to your legal counsel. What can we say? What can we allow in the meantime? And while this is going through and what do we want to do as philosophy of our board? Risking
and you
liability.
Have a role as a fiduciary trying to protect your school district from becoming a Supreme Court case and all the costs associated with that too.
Exactly. When Candace was talking about that grim case out of the Fourth Circuit, there was when the school district lost, you have to pay the other side's fees, which are over $1 million. And Jay Roroni used to always say when he would do these PowerPoints, you don't want your school district named in my PowerPoint. And that's really the truth, because even if you win, it would have meant a lot of money in legal fees.
Yeah. Okay. Thank you very much. Really heady, timely topic that is impacting us here locally, in addition to the nationwide impact. So thank you for your insight on that. So let's go to a lighter topic.
we Candace and I should be sent for 913 exams for picking these cases, but there you go.
Yeah, not easy cases, but these are the things that people have to navigate. If it was cut and dry, it wouldn't be worthy of your time, right? So let's dive into it. The Connecticut case. How are you covering this one, or do you want me to take this one?
Yeah, if you could take the next two.
Okay, awesome. So, in this case, we had a math teacher at Connecticut High School who had a rainbow flag with which most people identify as the LGBT flag, and also what's called a Progress Pride flag, which is similar to the kind of routine rainbow flag that many of us have seen, but there are also additional stripes meant to represent the alliance of the transgender community and people of color. This flag was up in the classroom. There was also a permission slip that the teacher was going to send out to parents regarding an LGBT youth conference. And the school ultimately asked the teacher to remove the pride flag and to also modify the permission slip for that trip. If we could move on to the next slide, we'll see that the teacher files a lawsuit in the Supreme Court of the state of New York, so not U.S. Supreme Court, but New York State Supreme Court, which is a lower court for our state, alleging that the act of having to take down the flag and modify the permission slip amounted to a hostile environment. As I mentioned before, certain things that we say may not be Title IX, but we could have an employee saying, now I feel uncomfortable and I believe that you've created a hostile work environment for me. They thought it was retaliation, discrimination, First Amendment, free speech, viewpoint discrimination. Many, many claims were included in that. If we go to the next slide, we'll see that the Judge Gonzalez in this case, ultimately found that the allegations did not amount to what's called an adverse employment action. So even if we take the plaintiff's allegations as true, that they had to remove the flag, that they had to modify the permission slip, it wasn't something that the court felt was harming the person's employment situation. They were not being assigned work duties that were not fitting for them. They were not having their pay cut or, being suspended from duty. They weren't terminated. So since it did not have a material impact on the terms and conditions of that person's employment, the employee essentially lost in that case. If we go on to the next one, we find that with regard to their claim about First Amendment violations, in order to say that a government actor, in this case the school district, engaged in First Amendment retaliation, the plaintiff needs to demonstrate that, number one, their conduct was protected by the First Amendment. Okay, let's say in this case it was protected by the First Amendment. Let's give them that. Once we move on to the second part, this is where it's a loser for the employee, because the employee would need to find that the government actor, the school district, took an adverse action against him or her. And as we talked about before, that was already found by the court not to be true. So that First Amendment claim was also not successful. Why don't we move on to talk about some free speech cases? And I won't spend a lot of time with the kind of background to this, because I know that many of you are aware that the First Amendment provides free speech rights to individuals, and it extends to various forms of speech, not just what we say, what comes out of our mouths, but also what we wear, different symbols, different political activities. All of those things can be interpreted as speech. And we come to the Arroyo Castro case, which involves speech in the form of symbols. In this case, we have Ms. Castro, who was a devout Catholic as far as she described herself. She had been teaching at a school district in Connecticut for 33 years, and she had a crucifix on the wall next to the desk in her classroom. It was a pretty noticeable crucifix. It was about 1 foot in height, and it was waist level, so it was in a place where students would be able to see it. The court was also careful to note that it was in a middle school classroom, and religion was not part of the social studies curriculum for those 7th grade students. And I mention that because if it had been a religion class, let's say, perhaps there could have been an argument that it was appropriate for that setting. But since it was not part part of the curriculum the teacher was teaching. It was ultimately something that people thought was meant to induce students into being Catholics or observing the Christian religion. This teacher for a while tried to comply with what the school wanted by moving the crucifix to a place that was less noticeable for about a period of one day. She put it lower down at her desk so that only she was able to see it. She said it caused her tremendous emotional turmoil. She thought it was very disrespectful to Jesus and to her religion. So she ended up putting it right back up on the wall where it had previously been, which compelled the school at that point to have her out on administrative leave for at least 2 days without pay, basically trying to ask her to rethink what she was doing because it was having a negative impact on her employment. And this teacher ultimately sued other administrators from the district and also the school district itself. And the court found in favor of the school district. They found that it was her duty as a teacher to decorate the classroom. And if she chose to put a crucifix on the wall, that was something that was pursuant to her duties, and the district had an ability to control her workplace duties. So it wasn't personal speech that she was engaging in at that point in time. It was work activity because if her job is telling her, I need you to decorate this classroom in such a way that it's going to be conducive to student learning, and you decide to do something that the school does not believe is conducive to student learning, they have the right to rein that in. And in the eyes of the court, that has nothing to do with your personal speech and your personal opinion. It has everything to do with the school being able to control the manner in which you perform your job duties. So that's the primary reason that she ended up losing in that case. But I want to quickly mention another case as a contrast because we see that the rights of employees when it comes to religious freedoms are something that we've got to be very careful about. Recently, and Howard and I spoke about this earlier today, there was a situation at the University of Oklahoma. Now, this is a higher ed context, but I think it sheds some light on why we need to be very careful about how we approach these religious situations. A student was asked to write a paper for psychology class, and the student cited the Bible as her only source. And within that paper, she said that there were only two genders, and she believed that it was basically an abomination for people to espouse theories having to do anything with transgender students. The teaching assistant who graded that paper found that the paper did not have any empirical evidence, that it was all based on the student's personal ideology, and that it was at times offensive. Gave the student a 0. Student goes to court and says, this is religious discrimination. Just because you don't agree with me, you can't give me a 0 in this class. And ultimately, the teaching assistant who gave her the grade was placed on administrative leave. It seems very possible that that teaching assistant may ultimately be terminated. And the school found that that grade of 0 could not be used against the student in a way that would harm her academic average or her academic performance in any way. So I think that perhaps the school would have been okay if they just gave her a 0 and said, listen, it's not based on scientific evidence and it was poorly written. But by going that extra step and saying, we believe this is offensive, that's when they inserted a personal belief into the situation that I think really got them into hot water. So we've got to be careful to leave our personal opinions out of it and to grade papers and to talk to students based purely on academic grounds.
Mm-hmm. So just one follow-up to this case. So let's say the crucifix wasn't on the wall, but let's say teachers are allowed to have various little knickknacks on their desk, and they had a small, and everyone could put whatever they want, things from sports games, whatever it may be, and they had a small cross on their desk. I think in that situation, the case would be a little different, because that would be viewpoint discrimination, and where it's part of your job responsibilities, according to this case, to decorate the walls. I don't know that it's part of your job responsibilities to have personal knickknacks on the desk. So we've taken a different view when it comes to that. The other thing is sometimes, you don't necessarily need to have a fight. In this case, because the crucifix was affixed to a classroom wall when there were students present, it's different. We did have a situation about a year ago where we had a teacher brought up on 3020A charges, got a terrible decision that resulted in the teacher not being fired. Teacher was put in the proverbial rubber room and was itching to for a lawsuit against the district. So decided to decorate his little cubicle area with some crosses, even though he had never been religious before. And what the school decided to do is, rather than give him a case in federal court to sue, they just ignored it. It wasn't affecting anyone. It wasn't in front of students. So, we don't always have to have a fight about this. And, sometimes we can just have conversations with people. We have had that happen about, teachers with Facebook posts that, we don't want to have a First Amendment fight with them, but we do remind them to be careful about what they are posting on Facebook. One case just to keep an eye out for, we do have a staff free speech case that we're waiting for a decision from a federal court on. You had a probationary teacher who was actually teaching a criminal justice class and decided to give an extra credit extra credit assignment on a Joe Rogan podcast in which some misinformation about COVID was being discussed. The school felt that it was inappropriate and inconsistent with, again, this was at COVID time, with the guidance that was coming out of the health department on COVID, and it wasn't related to the curriculum. They did not grant her tenure. She said that filed suit in federal court saying that violates her federal First Amendment rights to academic freedom. There have been prior cases that say, academic freedom may exist in the higher ed setting, but not necessarily in the K through 12 setting. So that's to keep an eye on. If we win that case, we will be happy to come back and talk about it. If we lose it, we'll just forget that we mentioned it here. So with that, we're happy to answer any questions.
So I have a kind of an overall question for you, kind of an advice type of question. You've been in plenty of executive sessions. You've been around boards. If you as a board and your district find yourselves in the middle of one of these legal battles, what are some key pointers that you could give to board members that when you're in the middle of this, don't do this, do that, right? Because again, we're dealing with highly emotional, highly politically divisive. You could be suddenly in the national spotlight and you didn't intend to, but now you're thrust in it. You're sitting in the exec session, emotions are riding high one way or the other among the leadership team. What advice would you give boards if you suddenly find yourselves in the throes of this?
So on the one, and I'll give my point of view and then ask Candace to weigh in on this too. So on the one point, we don't want school districts to live in fear and to be afraid of advocating and on behalf of things that they think are important. On the other hand, we do have competing groups that, this sharply divided country have right now that are looking for test cases. We also have a federal government that is very active right now, and with their enforcement of what they believe to be the right thing. We see that with DEI initiatives, and they have unlimited resources to litigate against entities, corporations. We even saw the biggest law firms in the country capitulate in certain circumstances to the government. So unless it's something that is really of importance, I think in this day and age, it may be better to try to keep a low profile on the controversial issues and keep the focus on the more day-to-day educating students issues. So for example, there was a lot of concern, about ICE agents coming on school grounds. We've given advice on how to deal with that, and we're sure all the other firms have it as well. We didn't think, even those schools that felt very strongly that ICE has no business of doing this on school grounds, not to advertise that, to put putting a bullseye on school. You can have that, but don't necessarily red flag it.
Don't
at this
couch chest,
yeah. I that's one. Or don't thumb your nose at either the state government or the federal government at this juncture. And I think the way to go is, if you're in betwixt and in between, and we had talked to our clients about doing what was done recently, is that if we find ourselves in the middle of enforcement action by one of them, to let the court system decide it via declaratory judgment motion. Um, so again, you can still do your advocacy, but just do it in a way that's very pragmatic and not necessarily is going to invite you into years and years of litigation. And I think that's one thing that becomes very frustrating for people, is just how long it takes to get for these cases to make their way through the court system.
Yeah.
It's forever, and it costs a fortune. So, stand on principle when you feel it's the right thing to do, but make sure you understand all of the ramifications, because principle is very expensive.
Yeah,
Yeah.
I think that's great, Howard. And I would add that although most districts do not want to be a test case, there are certain districts that feel very passionately about their position, and they do want to be a test case because they want to be very vocal about advocating for their position, which makes sense. And that's why we have cases that go forward to the U.S. Supreme Court, right? If a board is deciding to do that, it needs to make a conscious decision that it believes that the best use of its taxpayer funds will go towards defending or bringing that case, as opposed to getting technology for the students, making sure the security for your buildings is up to par, making sure that teacher salaries are commensurate with what's happening in neighborhood school districts. So it's not bad to take a stand, but we just have to understand what we could be compromising in order to take that stand. And I don't think that that's always completely thought through when we have a couple of school board members who feel very passionately about something, that
Yep.
these cases do not end in a year, and they don't end in 3 years that you're on the board. It's going to have ramifications long after you may no longer be on the board, and we need to make sure the district is ready to take that step.
Yeah, and the other thing is, make sure, this is one practical thing. I wouldn't do these things unless you had a cohesive board. So I wouldn't do this on a split board. I have had circumstances where a split board wanted to take a stand on something, and litigation started, and then two board members lose their seat, two others come in, and they want no part of that, and now you would have exhausted a lot of resources for something that gets withdrawn.
Yep. And the other thing I would say too, anytime you're in the middle of any legal situation, right, as a board, say very little, listen a lot, and let the messaging come from your PR folks, consulting your attorneys. Don't get in the middle, don't ad lib, don't allow a microphone to get shoved in your face, and all of a sudden you're really making matters worse. So thank you for that. Bernadette Smith from Pat Med put in the chat, New York's Civil Liberties Union had some good guidance on strengthening policy without standing up and volunteering to be punched. So
that's a great comment, and I think that sums it up.
Yeah.
I think do what you feel is right. That's your obligation. Do what you feel is right. But yeah, if you can avoid being punched, that is always a good thing.
Yeah. And understand there could be ramifications. I mean, I lived through it where you thought you were standing up and doing the right thing, and there are forces out there that now all of a sudden you're getting all sorts of audits that you never got as political retribution, and that's a very real thing, unfortunately, sometimes.
There is the power of government, and it can do that. And yeah, Rob, I remember that.
We lived through that together.
A completely crazy audit that was just, we're gonna teach you guys a lesson. So all those things. So the long and short of it is, have a full and complete discussion of all the possibilities and what could be unintended consequences of what you do.
This way you're making informed decisions and choices. Well, listen, folks, I want to thank Candace and Howard. You've given us so much insight, both on the cases you cited here and some of the stuff that has been percolating in the press, and you're still sorting out, and your expertise and breaking it down in very layman's terms for us, I think, is extremely important and very timely. And we always appreciate you taking the time and educating our boards on navigating the rocky legal waters out there. And listen, it's a great time to be an attorney, especially in this space.
Well, yes
It's
and
interesting,
no.
that's for
Yes
sure.
and no. It's interesting, but I think I've talked about it before. Whenever a new case comes down from the Supreme Court, I kind of keep a Pez dispenser in my drawer, and I fill it with Xanax, and I'm just like, what's happening next? So we do live in interesting times, but yeah, it's exciting. But again, consult your counsel on the front ends of things, and with everything that Candace and I say, again, your own counsel may have different takes on things, so please check with them too.
Absolutely. Well, we thank you very much. Once again, folks, on behalf of Nassau-Suffolk School Board Association, thank you for joining us. Enjoy the holiday season. Take advantage of the concerts. Get in there and remind yourself what this is all about, right? The concerts, the kids singing, all the festivities this time of the year. It's really a good mental health recheck as to why we do this. So thank you very much. And folks, a copy of this recording will go out. Also, we'll be sending out a brief, very, very brief survey to all those that attended live. If you can give us your feedback on tonight's webinar, and also that'll be your opportunity to suggest other topics that you might want to see in a webinar. We appreciate you taking the time out. And once again, Howard and Candace, thank you so much.
Thank you both.
Have a great
And
time.
everyone have a great
Thank you, Bob.
holidays.
Take
Thank
care.
you.
Happy holidays.
Okay.
Thank you,
Okay.
everybody. Good night now.